All right. I see it says live on YouTube. Okay. I'm calling the case of State of Kansas versus Doug Morris, 121733. Would the parties state their appearances, please?
Good morning. I'm Jonathan Lawrence on behalf of Mr. Morris.
May it please the court, Sean Minahan for the state.
Hey, you two are frequent flyers in the appellate court, so I don't need to tell you that we have read your briefs. We've looked at the record, and if you want to take Mr. Lawrence, just for anybody that's watching, a minute or two just to quickly summarize the facts of your case, you can, and I won't count that against you. But and did you wish to reserve any time for rebuttal?
I was hoping to split my time 9 and 6 if I could.
Oh, you are being complicated. Okay, yes, I can handle that.
I don't expect to use all the time on either side, but
we just lost Judge Bruns again. Okay.
Do you see me now?
Okay, he's back. Yes, I can see you now. But we lost our nice little picture at the top of the screen. Okay, go ahead, Mr. Lawrence. 9 and 6, you've got it.
thank you. Mr. Morris was charged in 1987 with having conspired with another gentleman to commit a homicide in Johnson County. He took what is known as an Alford plea, where he basically did not contest the charges, though he did not admit his guilt. Soon thereafter, he started a string of filings, what we call post-conviction filings, where he was claiming that his attorney had missed some things. And what it really comes down to is he's challenging the sufficiency of the document filed by the prosecutor known as a complaint to start the criminal process. He's specifically attacking the amended complaint from May 8th of 1986. And his complaints about the amended complaint are that the amended complaint did not.
Stop. We've lost Judge Bruns again.
Sorry.
All right, there he is. Okay, go ahead.
I could hear you, but for some reason my video keeps going off. I don't know why.
Okay.
All
All
right.
right. I'm sorry, Mr.
I can hear
Lawrence.
you anyway.
Go ahead.
Specifically, Mr. Morris complains that the charging document in this case did not list the element of an attempt. He was charged with not
The
only
overt act.
Right, the overt act, and did not allege any fact about an overt act, and did not correctly allege the mental state, the degree of what we call culpability associated with the murder charge. So that's generally the background.
Okay, your time starts.
Yeah, thank you. I wish to just raise 3 points today. One, dealing with the retroactivity of the Dunn decision out of the Supreme Court in 2016. The second, with respect to the concept of manifest injustice. And third, just dealing with this idea that there were facts written up by the parties appended to the case file after the plea. With respect to the retroactivity of Dunn, which is a legal question, the only thing that I wish to bring to the court's attention is, in the retroactivity analysis, what we're really doing is we're looking at this complaint. And I'm not being facetious, I'm just pointing out some irony here. Dunn was decided on July 15 of 2016, just 4 years ago this week. But on the Thursday, the 14th, the day before Dunn came down, a jurist would look at the complaint and say, I think it vests jurisdiction. Dunn comes down on Friday, the 15th. On July 18th, the following Monday, we would look at the same document and say, no jurisdiction. Retroactivity can be a complicated analysis, but what's really at issue here when we're talking about jurisdiction, it shouldn't be a malleable concept, because if it is a malleable concept, then it causes to ring hollow the phrases we've used in the past, such as jurisdiction can never be waived and it can be raised and challenged at any time. So if it didn't exist on Monday, July 18th of 2016, as applied to this 1986 complaint, it shouldn't have existed on Thursday, July 14, 2016, or even back in 1986.
Okay, Mr. Lawrence, I do have a question for you. So Dunn set forth 3 possible types of charging document insufficiency a criminal defendant may challenge. So let's assume for a minute that Dunn is retroactive and we're going to apply Dunn to your case. The first one was either a district or appellate court may be asked to decide whether the document shows that the Kansas constitutional minimums of correct court and correct territory are met. That's met here. That's not an issue.
Correct.
Second, a court may be asked to evaluate whether the document alleges facts about the intent and action on the part of the defendant that, if proved beyond a reasonable doubt, would constitute violation of a Kansas criminal statute. Are you saying that was not met here?
Yes.
Yes. The final one is the court may be asked to determine whether the charging document meets federal and state constitutional standards for due process and notice. Are you challenging that one too, or just the second one?
I believe I'm challenging the second and third. I think they're almost
Second and third.
a little inseparable when we look at this complaint.
Right, I get that. And so the court said the appropriate remedy depends on the nature of the defect alleged. So we're not going to have an implied waiver if you don't raise it soon enough, if it's to 1 or 3, but it perhaps can be to 2,
Right.
the sufficiency charge, okay? So going back to that, to the sufficiency charge, and I don't think you cite it in your brief, but Mr. Minahan cites it in his. We have State versus Sweet that I can't see anybody has ever overruled, nor was it overruled, I don't think, pursuant to Dunn, because it really didn't have anything to do with Dunn. The attempt statute is different from the conspiracy statute because attempt does not include a requirement that the overt act be alleged as well as proved. So doesn't Sweet or Sweat, whatever it is, doesn't that strike out your argument that they needed to allege an overt act?
Well, that's something unfortunately I'd have to say I'd have to give some thought to. I hadn't really considered it in that context.
Because basically what they did was they looked at the conspiracy statute and the attempt statute, and they say, look, the conspiracy statute says it says no person may be convicted of a conspiracy unless an overt act in furtherance of the conspiracy is alleged and proved to have been committed by such person or co-conspirator. And in your case, the complaint, the conspiracy charge, did list the facts that gave rise to the conspiracy charge. But in Sweet, a panel of our court said that because the attempt statute doesn't have that same language, then you don't need to allege an overt act in the attempt statute.
Well, if
So
if that case is controlling, then certainly that does not bode well for the second.
For the second,
Right.
your second
Right.
issue.
With respect to the third, when we look at the mental state as it's written, all of the boilerplate language modifies the word attempt and gives no notice as to the homicide.
Right.
Uh,
But that would be as to the third. And so you would say that based on reading the complaint as a whole, he didn't realize that's what he was charged with.
I believe we have to look at the 4 corners of the document, and it's,
Right.
I would argue it's defective.
Okay.
You touched upon the facts, and that was actually my third point, which was just to point out that the facts that were incorporated later went to the dismissed conspiracy count specifically, not to
Right.
the attempt.
Right. I understand that.
And
I think it did because the statute says you've got to allege it in a conspiracy. You don't need to allege it in an attempt. But
the one point I wanted to make with respect to manifest injustice in the context of a Dunn analysis, I submit that the traditional considerations when we talk about manifest injustice, and I think some of those I'm paraphrasing, but what's fair, what are the facts of the case, is continued incarceration unjust and illegal? When was this raised? I think those are all by the wayside, because when we're talking about a Dunn analysis, it is simply a matter of, was there jurisdiction or was there not? And if there's not, it's got to be manifestly unjust. The only other thing that I have today that I would like to just point out for consideration is, if the court believes that Dunn retroactivity needs to be addressed, and it hasn't been addressed. I looked this morning and I
Right,
believe
it
that
hasn't
there's-
been.
Right. I believe there's a procedural mechanism under Rule 801 that this court can either write an opinion and then I go through the petition of review process, or if this is the case, if this panel feels that this is the case to address retroactivity of Dunn, then I believe under Rule 801, there's a procedural mechanism through which a certificate can be filed with the Supreme Court.
I guess what I'm struggling with is how Dunn helps you.
Uh,
So even if we applied Dunn, if we assumed Dunn is retroactive for purposes of this case, and I might, I agree, it may be more satisfying to have us tee it up so that either you or Mr. Minahan, depending on how we rule, can appeal on that, on the retroactivity of Dunn. After reviewing Dunn in great detail, I'm having a hard time figuring out how it helps you.
My reading of Dunn was that all of the essential elements have to be in there with some facts. And
Right.
The other problem with if we go back to the second of the three Dunn possibilities,
Right.
there are no facts alleged in that attempt count.
Right.
And so that's where I believe Dunn helps. And I also believe Dunn lends support to my argument in terms of the fact that grammatically, the mental state for this homicide is missing.
Right. Okay. Any other? Let me ask, and I'm not trying to lay it on you, Mr. Lawrence. I just this happens a lot, and you talk about manifest injustice and what's the other one? Exceptional
circumstances.
Okay.
Right.
So your claim is both untimely and successive. I mean, those are the things
Correct.
you're fighting against,
Right.
just procedurally, untimely and successive. You can overcome untimeliness upon a finding of manifest injustice.
Correct.
And the case says that to be manifest, or the statute now says, it's limited to why was there a delay and is there a colorable claim of innocence? Well, your client doesn't make a colorable claim of innocence at this point, at least that I can see. Your issue is, so the issue is why the delay?
Right.
And the best I can figure out as to, well, why the delay is you're saying Dunn just came out.
Right. Dunn came out
But-
and we filed within a year of Dunn. And the
Yeah,
court,
but because but basically it's because the court kept, you've made this claim over and over again. And the
Correct.
court kept striking it down.
but if
So-
Dunn, right. And that's why Dunn's retroactivity is so important, because
Right.
when Dunn comes forward now, in other words, back to my original point, if on Monday, July 18th, a jurist in Kansas would have looked at this complaint, July 18th of 2016, and said, well, now under Dunn, there's no jurisdiction here, then that's why the retroactivity is so important, because if there was no jurisdiction as of July 18 of 2016, there shouldn't have been jurisdiction on July 14, the day before Dunn, and all the way back to 1986. I think that the other fact of the case procedurally, which lends support to what I'm arguing, is that the district court did find that Dunn is an intervening change in the law, which was another example of exceptional. It was one of the factors for
Right.
exceptional circumstance.
Yeah, that's the exceptional circumstances, which
Right.
goes to the successiveness of
Successive,
it, not the
right,
untimeliness
right.
of it. Okay, I'm sorry. Any other questions? Thank you, Mr. Lawrence.
Thank
Mr.
you.
Minahan? You can go
Sorry.
ahead.
I'm so used to doing these now that I just put it on mute, and That way anything is around. I'm not sure how Dunn helps the defendant in this case. Dunn basically says that there's only two types of errors in the charging document that amount to subject matter, a violation of subject matter jurisdiction or lack thereof. And that's if the charge is filed in the wrong county or the charge is filed in the wrong court. Well, there's no dispute that this was filed in the right county, Johnson County, and in the right court, the district court. The other two prongs really get to kind of a due process issue, whether there was error in the charging document, and if so, whether the defendant was harmed by this. With that being said, I think that the defendant has a few issues with his argument. First is waiver. He pled to the cases, to the crime in this case. So he basically agreed that what the facts that were presented to the plea court, the state could prove up. And also res judicata. He's raised this at least once, if not 2 or 3 times in the courts over the years. As you pointed out, Judge, State versus Sweat, for his issues, overt act, State versus Sweat found that you don't have to charge an overt act in the complaint. No mental state, the attempt itself is a mental state. You have to intend to attempt something. And then harmlessness, again, there's no doubt that he knew what the facts were, what the state was arguing that he did to commit the crimes. So with that, I don't have anything further.
I've got a question just to make sure I understand the facts. Did he plead early on in the case, or was there a separate plea hearing held? Did he plead at first appearance? I'm not clear when he pled, you know?
I think he pled, I mean, I don't know what months, but it wasn't he had counsel, and they did up a lengthy statement of facts.
Well, that was my next question is I've read in the record someplace that there was a 4-page statement of facts. Was that something that was signed by both parties, something that was just articulated by the state at the plea hearing, or can you help me with that?
No, I think that I read in my brief that he had signed it, even the defendant had signed it.
Well, I thought I had seen something like that, and maybe Mr. Lawrence can help us on that too when we get back to him. But
yeah,
because, and my reason for asking is I'm an old district court judge, and if I didn't really care much about the complaint once they came in and pled and actually stated the facts, and the defendant was allowed to articulate whatever they wanted to, and said, hey, yeah, I understand that they can prove the facts to find me guilty, even though I may not agree with them. And usually that was enough. I can't even remember going back and looking at the complaint or information at that point.
Right.
Am I all wet on what the case law is on that?
No, I think you're right. And I think that's what kind of Dunn is all about, is that, as long as you've charged in the right county and in the right court, then it becomes an issue of harmlessness. Was the defendant fully informed of the allegations that were made by the state? And when you plea, you're kind of admitting to the elements and that the state can prove those up. So
because sometimes, it's different than, because of a plea negotiation, you end up stipulating to things or dismissing charges and amending charges. Okay,
Is it
and
different in an Alford plea?
yeah.
no, I don't think so, because it might be in terms of if you're arguing actual innocence, whether he pled guilty or not. But in either situation, the defendant's agreeing that the facts that have been set out to the court can be proven by the state. So in this situation, I don't think it matters.
Well, in an Alford plea, he knows the court accepts it and finds him guilty.
Right.
So how does res judicata apply with this case when he's previously raised the argument in a prior 1507, but now claims Dunn changes the world?
Well, it applies because he's already had a bite at the apple on this issue. I mean, anytime you look at these, I guess, retroactivity, you're dealing with, variables on prejudice to the state and prejudice to the defendant. Could you imagine trying to take this 1986 case and trying for the state to try to find all the witnesses, find all the evidence that, was probably not fully set out and ready for trial at the time of the plea. And, it would be a nightmare. And that's why we have not only res judicata, but waiver and exceptional circumstances, manifest injustice, because there's a balancing.
So to be clear, what's your position about the retroactivity of Dunn?
I don't think it's retroactive because, and maybe I'm arguing against the state because it's better that it's retroactive for the state because Dunn's a better standard for the state.
Well, it takes subject matter jurisdiction out of play in most cases.
Yeah. But this is Dunn is a case that the Supreme Court basically cut off all of the Hall and the pre-Hall analysis and started anew with a new standard, although supported by federal case constitutional law and things like that. And so this isn't a continuation of old law, which would mandate retroactivity or at least allow for it. So.
I guess I'm having a hard time seeing how Dunn helps the defendant when there's no doubt the case was filed in the right county in the right court. So how does, I'll be devil's advocate, do you think Dunn would help the defendant? Mr. Morris.
I don't think.
Oh, we haven't come back to Mr. Lawrence yet. Did anybody have any more questions of Mr.?
Yeah. Oh, I'm done. Sorry.
No, I was asking Mr. Minahan.
Oh, I'm sorry. Okay.
As a devil's advocate.
Yeah, I don't think it helps him. Pre-Hall and Hall used to have stricter standards for complaints. And now it's simply a matter of is there error and was he harmed, except for the subject matter jurisdiction elements, which are county and district court. So, and those are.
I think they said the notice there'd be no implied waiver on the third. The court may be asked to determine whether the charging document meets federal and state constitutional standards for due process and notice. You don't get an implied waiver there, so. I think what that means is that's not subject to harmlessness if he's able to establish that. But I may be wrong.
Yeah, I don't think that's what it means.
Okay, all right. Okay, Mr. Lawrence, you've got 6 minutes.
Okay, thank you. I may be going out on a limb here. I'm just trying to clarify factually and with what I have at my disposal. What I do not have is the 4-page statement of facts. My recollection is that was filed subsequent to the hearing. I know it's in the record. I know that when we were compiling the record on appeal, one of the things that had to happen was for the district court clerk to go to archives and get it was a paper file. And then I think when it was scanned in, it's one enormous PDF. But and I think that the actual filing date of that document coupled with what is in the guilty plea hearing transcript, and this was in January of '87, and that's cited in both of our briefs. Specifically, I think it's easy to put your hands on it, but I think that'll answer the question. As I recall, the statement of facts was done later. So I hope that
Well, it was unclear to me. That's why I asked the question. And then
Right.
just, what's your position then on the follow-up, which is usually when somebody came before me and they were pleading and
Sure.
they stipulated all these facts that were good enough to show an attempt, that was usually good enough for me.
Sure. Please don't take my answer to be facetious. I'm not, I mean, in a purely legal context, subject matter jurisdiction comes before the plea.
Oh, I agree, but we're not
Right.
talking about subject matter jurisdiction here any longer, are we?
Well, you're talking about waiver, right? You're waiving him into the jurisdiction of the court. If that charging document's defective, then ab initio, there's no subject matter jurisdiction. Him taking an Alford plea would not waive those, the lack of jurisdiction of the court, unless the only way, and again, not to be facetious, but the only way a criminal defendant could waive subject matter jurisdiction is to just sit in prison and never say anything, which brings us to the res judicata. It's almost like he's whipsawed. He's been arguing this since shortly after his plea and sentencing. He's been consistent in maintaining this same argument all the way through, which I do believe now Dunn acknowledges. By analogy, and I hate to do this because I think it's poor form, but I had a case, I don't have the citation, but in 2005, I had a case, State versus Hobbs, which was, we challenged the warrantless blood draw process in a DUI, right? It was a DUI homicide or manslaughter. And we challenged the warrantless taking of Mr. Hobbs's blood over his objection when he was strapped down in a gurney at a hospital. And of course we lost. And then a few years later, and I cannot remember just off the top of my head, I cannot remember the name of the case, but of course that is now unconstitutional. There was a series of cases that came down in, I believe, like 2012. We were in the 10th Circuit at the time on a federal habeas litigating the same issue. And the idea was put out, well, that new change in Kansas law benefits every single Kansan except Mr. Hobbs, the one who came up with the argument initially in 2005, right? And I feel like we're here again.
It's like, what else do you have to do?
Mr. Morris has been consistently arguing this, and I know I'm not putting words in Mr. Minahan's mouth, but let's say that I just came forward with this argument about Dunn and the wording of this complaint in the 2000, I don't remember if I filed it in 17 or 18. I think I filed it in 17. If I came up with this idea that the complaint was defective in the successive 1507, the state would be arguing, oh, I mean, he's raising this for the first time in a successive post-conviction document. The point being, here's a litigant who has been complaining about this for 31 years consistently. He's not changed the argument. And so, although you can conveniently invoke res judicata, when you analyze res judicata, wouldn't res judicata give way to retroactivity under Dunn? Otherwise, there would be no such thing as retroactivity ever, because everybody who comes in and argues retroactivity always has in the background the state's res judicata argument.
Help me understand, Dunn. I've got my thoughts on it.
I think my
It
time's
seems
up.
it seems that as far as subject matter jurisdiction, it's basically taking the complaint out of play, with the exception, are you in the right court, the right venue, etc. And then it goes on and it says, but you can still show that a complaint is defective. Let's say the complaint is defective in the way that your client claims that it is and has claimed for 31 years consistently. Does that deprive the court of subject matter jurisdiction, or just does that mean that it's a defective complaint, which is a little different standard?
It's a tough question. The
Well, that's what they left open, I think, maybe.
the only way I might be able to answer it is that might go to the remedy, right? That might decide whether or not, if I'm correct, the charges are dismissed and he's released, or instead is the case remanded for further proceedings to allow the state, for example, because at the end of the day, we're back to the idea of contract principles with a plea bargain, right?
Right.
If Mr. Morris is let out of the Alford plea, is the state, right? And I think it would only be fair in that instance, the state is let out also, and we start over again. as to the fairness, it's equally as unfair to Mr. Morris as it is to the state, because again, he didn't just blindside the state and bring this up in 2017 or 18. He's been arguing it since shortly after his sentence. He is equally as hamstrung with respect to witnesses and things of that nature. And so bring it full circle to the manifest injustice prong of the analysis. His sentence was a 15 to life, but under the parole statutes at the time, he had his first parole hearing 7.5 years in. And I think that even though neither party addressed it in terms of the actual math, if you look at the state's statement of facts, I was reading this yesterday, there's mention of his first parole hearing, and it gives the dates. And if you notice, it was well before the 15th year, right? Which I believe was he was eligible every 7.5 years. He's been in 4 times longer now than his first opportunity for release. So I believe that also is a factor that weighs in his favor.
Okay, thank you very much. Any other questions? That will conclude this matter then. Our rule is that our goal is to get cases on file, meaning put out on a Friday within 60 days from today. And we are pretty good about meeting that goal. So we will meet in conference today and start writing soon, and hopefully get an opinion out to you within the next 60 days. But we appreciate your arguments, and we'll go from there. Thank you.
Thank you.
Thanks.